Good morning, everyone. This is George Spees with the Pennsylvania Office of Open Records. Welcome to this morning's webinar where we're going to be discussing laws that protect information. Let me go over a couple of preliminaries here before we dive into the actual session. First offhand, this session is being recorded, and those recordings are available in a couple days on the on the office's website. You go over to the training tab, you'll be able to scroll down, find a link. Also, if there's a chance that you would need a copy of it, you can email the office and they'll provide a link to you so that you can have direct access to it. That usually takes a couple days. If you're familiar at all with these webinars, they're essentially PowerPoint based with me talking in the background. The PowerPoint is also available on the office's website. Again, scroll over to the training tab and then go down and you'll find all of the PowerPoints that we use for our training. And you're welcome to access and use any of them. It may be that you had a colleague who wasn't able to attend this morning and you'd like the opportunity for them to review it. Maybe you just need it for your own future reference. Or perhaps you're conducting some local training and you'd find it helpful to have some resources. They are public records as far as we're concerned, so you're welcome to use any of the materials on our website. As far as questions go, you're welcome to type in the chat feature, your questions, but keep in mind two things. First is that we are talking about laws that protect information, so let's try and stay on topic. And second is that the more succinct and brief that your questions are, the better. What happens is occasionally people will type in several paragraphs and it just gets awkward for me to sit here and read through it while everyone else is waiting patiently. If it appears that you've got something really complex or unique to your particular situation, we'll do one of two things. We'll wait until the end of the presentation and I'll come back to it and address it for the good of the order for everyone. Or we'll take the conversation offline where you're encouraged to reach out to the office at some other point with your questions. The phone number and the URL for our website are on the screen right now. And when you contact our office, the first person you're going to usually talk to is one of the administrative staff. They are very well versed in the right to know law and can usually get you headed in the right direction. If not, let's say you stump the panel, your question will get escalated to one of the senior executives. And they're also pretty good about getting back to you within, I'm going to say 24 hours. Although recently the office has been breaking records for the amount of work that's been coming through, with both requests coming directly to the office as well as, more importantly, the appeals. And, it might take a little longer than 24 hours. I know that they're doing their best. Your questions are important. We figure, you're under time constraints usually. So we do try to get back to you, but lately with all the work that's been going on, it's just been more difficult. I hope you understand. Okay, looks like we have a well-attended session this morning. So, all that being said, let's dive into the presentation here and talk about laws that protect information. Okay, first off, Anna, I want to address why is this important? You need to be familiar with the minutiae somewhat of the right to know law to understand why there are other laws that involve the confidentiality of public records that are just as important as the right to know law, and they kind of all fit together. So let me do my best to explain that. First offhand, there are other laws that can remove the discretion that exists in the right to know law. Okay, under the right to know law, you've got the 30 exemptions, 708, section 708B, and then you go 1 through 30. Now, if you're familiar with my session on the right to know law, okay, someone is saying they don't have any sound. That could be a problem locally. We did test the mic earlier and it seemed to be working. If someone is hearing my voice, could you type in real quick that you do have sound? Okay, so it's a local problem. Unfortunately, I think what she has to do is log out and log back in. That usually takes care of it. Okay, and thank you for the responses. So getting back to the slide here, those exemptions that are definitions of records that can be withheld by the agency are discretionary. Under the right to know law, the agency, if it is applying one of the exemptions to withhold a record, they can also decide not to invoke the exemption, okay? But if there is another law, and this is outlined in section 306, if there is another law that says this record is confidential, that supersedes or trumps any discretion that the right to know law would otherwise afford the agency. So if you're applying just the right to know law, you have a choice that says we can either withhold this record or we can choose to release it, to grant the request. But then comes these other laws that we're going to be talking about this morning, where in almost all cases, they say this record is confidential, you may not release it. Thus, the other law, according to section 306, trumps the right to know law. Nothing in this act shall supersede or modify the nature of a record established by federal, state law, or a judicial decree, meaning a judge's order. Okay, that takes precedent over any discretion afforded to the agency in the right to know law. You must withhold the record. Otherwise, typically you'll find you'll be in violation of that other law. Okay, I am scrolling through the comments here and I see we have, okay, yeah, it looks like the sound issue is okay. We're using a new system here. I'll just take a moment to explain this. And the chats do not automatically advance. And in past weeks, I have missed comments and questions because I have not manually advanced them. So periodically, I'm going to take a moment and just scroll through to make sure I'm not missing anything. Okay, back to work here. The second reason why it's important to be aware of these other laws is that under the right to know law, if you recall, the agency bears the burden of proof, meaning it's not up to the requester to say why the record is public. It's up to the agency to legally prove why the record is not public. Okay, typically you would refer to one of those exemptions in the right to know law, but there are those instances where the agency can meet its burden of proof by referring to one of the other laws that are controlling. And we'll go through, I mean, that's the purpose of this whole presentation, is to make you aware of what other tools are out there for agencies to use to establish the legal basis as to why they will not be granting a right to know request and thus releasing the records. Okay, so it's additional tools in the toolbox, if you will. But one of the things that, you know, if you're here from the public side, the requester side, you need to be aware that in many cases, agencies have no choice. They cannot release records for fear of legal sanctions if they were to do so mistakenly. All right, let's move on here. And the first one I want to talk about is a big one. It is typically used by police departments, and it's called the Criminal History Records Information Act, or CRIA, as it's more commonly referred to. Now, CRIA applies to any person or agency that collects criminal history information. So it would typically be police departments, prisons, district attorneys, sheriffs, courts, any law enforcement agency as defined by CRIA. Okay, now, I want to emphasize here that whenever you're dealing with a law, it helps to look at the definition section, because we have this term police department. Under CREA, it's a rather clearly, narrowly defined definition. Okay, well, whatever. As to what a police department is, okay, and it deals with, having the appropriate certifications and so forth. That's important because there are other laws that define police departments much broader. For instance, if you're familiar with Act 22, which governs public access to video recordings, dash cam, body cam, security cam footage that are under the control of a police department. A police department is simply defined as any agency that employs a police officer. Now I'm paraphrasing there, but that's in essence, that's what how it defines it. Okay, so under Act 22, a police department can be a school district. Okay, clearly under CREA, that is not the case. So these two definitions are, you could say they're in conflict with each other, but at the end of the day, they are different definitions, and it helps to be aware of that fact. So back to CREA, we're dealing with basically certified law enforcement agencies. And what CREA says is that the information that falls within the definition, those records that fall within the definition of CREA, can only be shared with other applicable law enforcement agencies. So you could only share records with other certified police departments / law enforcement agencies. You would not be able to invoke the definition of a police department as defined by Act 22 and have a police department share CREA covered information with, for instance, a school district or a railroad that employs a police officer. That simply can't do it. Now, CREA, in essence, protects criminal history, investigative, and intelligence information. Okay, that's a somewhat broad definition, but I think that, CREA is intended to cast a broad net. Now you're thinking, what's the difference between this and 708B16 of the Right to Know law? Well, the Right to Know law makes no mention of criminal intelligence information. Okay, so if I were to strictly apply just the Right to Know law, and someone were asking me for our file on suspected gang activity within the jurisdiction, I would have to release it because there's no reference to intelligence information in the Right to Know law. But I go to CREA, and CREA says, you withhold police intelligence information. I cannot give that out. Okay, which is why police departments, in meeting their burden of proof, oftentimes will invoke CREA because of its broader definition of sensitive information and the fact that there are sanctions involved if they were to mistakenly, or for that matter, purposefully release information covered by this law. Okay, so that's what's going on there. Now, granted, this is a very quick down and dirty explanation of what CREA is, but if you need further information, let's say you're from a law enforcement agency and you're somewhat new to all of this, I strongly recommend reaching out to the Pennsylvania Attorney General's office. They're the point agency on CREA, and they have a very useful handbook online on their website that you can download for free, and it will provide you much more detailed information on what CREA is, how to use it, how it applies, what you need to look out for, and all of that. And there's nothing secret about it. If you're here simply as a curious member of the public, it would probably prove very useful as well. And also, like I said, reaching out to the Attorney General's office. When I was originally putting together this session, I did that, spoke to a couple attorneys over there. Very, very helpful. And again, I can't say enough about the usefulness of this particular resource. Okay, let's move on. And let's talk about Act 30 of 2016. This applies to what are defined as public safety answering points, okay, which in essence are your county 911 centers, okay. You got a situation, You pick up the phone, dial 911, it goes to one of these county 911 centers in most cases. I think there are still limited instances where you've got police departments where the 911 call will go directly to them, sometimes like maybe during the daytime hours, and then at night it shifts over to the county. There may be, a handful of those left. But if that's the case, this law still applies to the police department as well. That's why it's called the answering point. Okay, and this protects individual identification information of callers, witnesses, and victims. That information would be in the form of the name, the telephone number, and the home address of whoever is involved with the emergency incident. This would be like, usually what happens is someone will reach out, they'll file a right to know request with the police department or the county 911 center for like a copy of the recording of the telephone call that was made. Maybe, there was a noise complaint. So the person who the department investigated, because of the noise, the party or the loud stereo or whatever, they'll get upset and they'll say, I want a copy of the recording because I want to know what was said. Maybe I'll be able to tell who the caller was, et cetera, et cetera. Well, that information is protected under Act 30. You can't get it. And also, you can refer to the right to know law, Section 708B18, which is a very clearly and strongly written exemption where it's going to be withheld, unless they choose to release it. But under Act 30, again, their hands are tied. It's somewhat limited as to what information can be given out. Now, what can be given out are, like when you're talking about the location of an emergency, they can't give out the actual street address, but you'll hear this like on the media, like if there's an incident somewhere. And I particularly, I use both the radio and GPS just about whenever I'm traveling someplace. And a lot of times you'll get, especially with a commute, you'll get, there's a police incident on this particular highway or something, you want to avoid the area. Okay, and they'll give the location in general terms, but not an actual street address. Well, that's because Act 30 limits what you can give out, but you can give out like the block number, cross street, or mile marker. Quick example, I'm here today working in the building. The address is 333 Market Street. But let's say there were a fire here. Okay, well, what can be released is the fact that the building is located in the 300 block of Market Street. It's at the corner of 4th and Market. And if we were out there on a state or US highway, you could give out the mile marker, for a potential accident and traffic backup and so forth. Okay, but you can't give out an actual street address. So that's how Act 30 works. Okay, next one we have, and I apologize for jumping around here, but that's just the nature of what we're dealing with. And this is attorney-client privilege. Yeah, I'll just mention that we basically pick out the most common legal cases that are, or legal bases that are used by agencies, and what we have to research here at the Office of Open Records and be familiar with how they work and whether or not that represents a valid legal basis for withholding the record. So we pick the most commonly used ones. And that's why there's a lack of continuity and it jumps around a bit. But this one is attorney-client privilege and attorney work product. Attorney-client privilege is based on law, the rules of evidence in Pennsylvania. And essentially it protects any sensitive information between an attorney and their client that ends up being exchanged. For our purposes with the right to know law, we're essentially talking about agency solicitors and their client agencies. And, when I use the term agency, or when we use the term agency here, we're referring to state departments, state boards, various offices. At the local level, we're talking about cities, boroughs, townships, authorities, school districts. A natural extension of that would be public charter schools and the like, okay? So it's a generic term that's used to cover basically all government agencies that fall under the jurisdiction of the right to know law. But attorney-client privilege clearly is something that we come up against fairly often. And it protects, attorney-client privilege protects that communication between lawyers and their clients. So privilege is lost, okay, and this comes up periodically, when that confidential information is shared with the third party, whether intentionally or not. Usually what will happen is that you'll have a solicitor providing legal advice and guidance to, say a council or a board. And one of the members, for whatever reason, will release the details of that conversation. Okay, at that point, privilege is broken and that information becomes public. But if that doesn't happen, then privilege is maintained, and the agency can say that these records represent attorney-client privilege, and as such, we're not going to release them. We're invoking attorney-client privilege. Okay, now that can still be appealed to the Office of Open Records, and we are one of the few tribunals in Pennsylvania that has the blessing of the Pennsylvania Supreme Court to determine whether or not, in fact, attorney-client privilege does apply. Okay, this usually comes up in general with the right to know, where people will submit a right to know request to see the invoices that a solicitor or a solicitor's firm is submitting to the agency. They want to know how much is it costing us to pay for this attorney. Usually, either they're on a retainer or they're paid on a per hourly basis. So the invoices are requested. And the question comes up, are the invoices covered by attorney-client privilege? Well, that depends just how detailed the invoices are. If they're simply, we're charging you X number of billable hours for this month or this quarter or however the billing cycle takes place, chances are that that would be a public record. It would be considered a financial document with no strings attached. If, however, the solicitor goes into greater detail in what those billable hours are, then it may be that if you can discern legal strategy or some other sort of work product from the detail, then it's possible that you could apply attorney-client privilege. For instance, I'm billing you for 3 hours for research I did in case law related to this particular defense strategy on this case where XYZ company is suing us. Okay, or I spent 9 hours deposing these potential witnesses to establish, again, the defense on this particular case. It's possible. Okay, my advice is, when in doubt about whether or not an invoice rises to the level of attorney-client privilege, ask your solicitor. Okay, and again, if the requester disagrees with records that are being withheld, they can file an appeal and we'll sort it out. Okay, question has come up. Can you clarify when an address can be withheld? We get requests asking for police incidents at a certain address. Okay, what you're talking about wouldn't be Act 30, because Act 30 only applies to the answering points. If you're receiving 911 calls, what you're talking about would be police incident reports. And oh gosh, I don't know whether I covered it here, but I don't. We have another webinar on right to know law for law enforcement. And Joe, all I'll say is that it's been determined through case law that police incident reports are inherently investigative, meaning Section 708B16 of the Right to Know law applies. Thus, police incident reports are not considered public records. Okay? Without going into great detail, if you have further questions, reach out to the office. But that's the takeaway here. Police incident reports are not considered public records. I would suggest sitting in on that other webinar when we schedule it. It's called Right to Know Law for Law Enforcement. Okay, good questions. Keep them coming, folks. And for whatever reason, our chat feature is automatically advancing, which yay. Okay. Yeah, I think that pretty much covers attorney-client privilege. Let's move on. And yeah, here's another one that comes up. The Uniform Construction Code, or what's more commonly known as UCC. This is Pennsylvania's statewide building code. And it applies to any agency, any municipality that would be in possession of building permit applications, plans, and associated records. And what the UCC does is protect those applications, building plans, specs, inspection reports, and similar documents. Okay, so it's basically everything soup to nuts, except it's for buildings constructed after 2004. Okay, why is that? Well, that's when the UCC was adopted by Pennsylvania. Prior to that, and I'm old enough to remember when this happened, a local municipality could have its own building code in place. And for instance, we had the BOCA code, if you remember that. Let me think, there was the Uniform Life Code, I think is what it was called. That was another one. And you would go from municipality to municipality, and you would have different building codes. And it became really hard for contractors and developers because you never knew, or you had to do research and be intimately familiar with each municipality's building code. So the legislature said, okay, we're going to have a uniform statewide code. So it became effective in 2004. If you're looking for records that predate 2004, number one, you need to be aware of the municipality, the jurisdiction, and what building code would have been enforced at the time the building was put up. And you get some of these really ancient structures, there may not have been any building code at all, who knows, but you gotta be aware of that. Now, in red, everything is detailed as to what UCC protects, but the building permits themselves, and it's interesting because we had to get a building permit at our home because it was work that they just started working on this morning, and we had the permit sits in the front window to let everybody know we have permission to get this work done. The permit itself is a public record, okay? That can be released. If I submit a right to know request to the municipality, I'd like a copy of George's building permit, then that's acceptable, okay? You can get that. All right, question has come up. Doesn't it create a conflict when building plans are included in a zoning hearing board application? Okay, zoning hearing boards are a different animal. That's not covered by UCC, okay? That's covered by I think it's the Pennsylvania Municipal Planning Code, all right? And you want to refer to that when it comes to what information can and can't be released on, all right? Different law, and I'm not including it here because of the protections in the zoning hearing. Okay, does UCC apply statewide? Yes, it does. And you do not have to adopt it because it's a state regulation or state law. So each municipality doesn't have to adopt it. Now, here's something that you need to be aware of. It's a common misconception that UCC only applies to commercial structures, okay? However, our office back in 2012 issued a ruling that has been upheld to this day that includes residential structures as well. Now, from a legal perspective, you would have to read that particular decision, which you can find on our website, Ness versus York Township. The decision is pretty interesting because it's not based on what is said in UCC, but rather what isn't said. All through UCC, there are references to commercial structures, that this law applies to commercial structures until you get to the privacy provisions for the release of records. And there, the language changes, where it doesn't say commercial structures. It basically says structures, okay? The word commercial doesn't show up. So our office, using that language, argued the case that when it comes to the release of construction records, it now applies to residential as well as commercial. Now, there are some people who hem and haw and say, okay, you guys are, incorrect in your reasoning here. But I'll tell you that 12 years later, our logic still stands and it carries the weight of law. And when you look at this from a common sense approach, why would you release building plans for someone's home? Okay, I think that would be problematic. So just bear this in mind that, if you're like a codes enforcement officer or, you're working with building permits and so forth, if you get a right to know request for a residential structure in building plans and so forth, you should withhold those, or you can withhold those as well. And our logic would be that you should withhold them based on the language that actually doesn't appear in UCC. Okay, it's kind of reverse logic there, but if you take a couple minutes to think about it, it works out. Now, what about if I've employed a contractor to make renovations to my home and they would like to see, or my business, let's say business, that makes more sense, and they would like to see all of the building plans that have been filed over the years for this particular structure. How do they get them? Well, under UCC, there is a clause that says, as the building owner, I can give my permission to anyone who has a need to know situation, such as a contractor, a developer, maybe a new owner, okay, or a potential owner. They want to see everything that's happened to this structure over the years so that when they go in and do renovations and so forth, they know what's behind that wall, or they know, what's holding up that ceiling or whatever. All right, so it can be released with the current owner's permission. And then, like I said, in response to the one question, this does not apply to zoning boards, okay? The municipality's planning code is the law that you need to look at there. And because of the nature of that, that's an adversarial setting where the planning code usually comes up. We don't, the Office of Open Record doesn't deal much with zoning issues. And then finally, if there are any citations due to a building code violation, those can be accessible if the dispute over the violation rises to the level of a court action. If the courts are involved, then it becomes a court record. And in Pennsylvania, most court records are considered public. You don't access them through the right to know law, but you access them through the court's Rule 509 process. And that's how you will get those records. All right, let me get a sip of coffee and advance to the next slide. Yeah, now we're going to get into the ABCs of health-related laws, because this comes up not periodically, but the first one is probably the one you're most familiar with. It's HIPAA, okay, the Health Insurance Portability and Accountability Act of 1996. Again, I'm old enough to have been around back then and remember when this took effect and the impact that it had on agencies that were in possession of medical information for our employees. In a previous career, I was a human resources director for a large state agency. And yeah, we had to make some significant changes when all of these laws came about. Now, HIPAA is interesting because, again, it's another misunderstanding where most people think that it applies to employers, but typically the majority of provisions within HIPAA apply to healthcare providers. But essentially what it's saying is that you cannot release individual identifiable or personal health information. Okay, now, where it does apply to agencies is where an employee may approve the release of health information to the employer. Okay, but then the employer needs to keep it private. Okay, most medical information is confidential between the individual and their healthcare provider. But every so often, because of, the details regarding a medical condition, the employer or the employee will say, I'm voluntarily releasing this to my boss, to my employer. But then it is the duty of the employer to keep that information secure. Okay, so you would not release any health-related information if requested through the right to know process. And you've got two immediate sources of ammunition there. You've got the provision in the right to know law itself, which protects health-related information for employees. And then you have HIPAA, which says, you may not release any health-related information. And HIPAA includes sanctions, fines if you were to release it. So you want to be, very careful about anything like that you would release. Okay, but fairly straightforward. The next medical law that we want to talk about is FMLA, the Family Medical Leave Act. Now, this does apply to employers for the most part. And within the staff, if you're large enough to have this, it would be any human resources leave administrators and the employee's immediate supervisors. FMLA, in addition to many things that it covers, protects any leave or accommodation. Remember that? Reasonable accommodations, related records that could disclose the presence of a serious health condition. Okay, that's the key phrase that, for years, everyone with FMLA struggled with. What is a serious health condition? Because the language is somewhat, and this is my HR director had, I always considered it a little vague, and it took us years to kind of figure it out and relying on case law, and also somewhat subjective. But, I think it's kind of been sorted out these days. It covers more than it doesn't cover from our perspective. But for our purposes, I think we need to be very careful about any leave and accommodation related records and ensure that we just don't give stuff like that out. Now, occasionally you will have an employee, like I was talking about under HIPAA, who will voluntarily disclose the presence of a serious health condition. Okay, let's use the example that someone suffers from epileptic seizures. Okay, well, the employee notifies their supervisor that, hey, I've got this issue, and if I have a seizure, that may be what's happening. Now, the supervisor has the responsibility to only release this information on a need-to-know basis. Let's say that the employee does have a seizure. So they dial 911, the first responders show up. The supervisor, based on that scenario, may now release the information. They can say to the first responder that this employee notified me that they suffer from epileptic seizures. And then the first responders will have that information in relaying it to the appropriate source for the diagnosis and how they should proceed with treatment. Okay. But the supervisor would not release this to anyone else to protect the privacy afforded to the employee under FMLA. Now, another area where you need to be careful is the record of absence. And let me put on my HR hat here and go into a little detail. If an employee is out sick for 3 days or more, the agency should, and I put that in quotes, should be sending a survey form to the employee saying, is this absence due to a serious health condition? And if the employee says it is, well, then that affects their FMLA leave balance, okay, which is different from any leave balance that may be afforded the employee through a contract or just as a general policy, okay, but then those days, those sick days, get deducted from their FMLA balance. Okay, so if someone submits a right to know request for someone's leave records, think about this. If it shows a 3-day gap, you could potentially be disclosing the presence of a serious health condition, which would put you in violation of FMLA. And, sometimes people will do this. They know that their next door neighbor works for the borough, but they see them out mowing the lawn. Okay, well, is he doing that on the clock? Or, you're thinking this is silly, but, people do this. Okay, so you want to be very careful about revealing any record of absence in response to a right to know request. I would recommend not doing it, okay? But again, you need to meet your legal basis for why you would not release that. And I would probably take a look at FMLA and say, well, we could be, potentially divulging the presence of a serious health condition, and we don't want to do that. Because if you do, the agency, again, could be subject to sanctions if the employee turned around and filed suit against them. So something you want to be very careful about. Okay, let me just check to make sure I'm not missing any comments or questions. Yeah, it looks like we're good. Okay, ADA, the Americans with Disabilities Act. This again applies to most employers, including government agencies. ADA protects all medical records, requires that they are stored separately from other personnel-related records. Again, I remember when ADA came out, and we had personnel folders that were hard copy back then, and they were all kept in file cabinets. And I remember our benefits staff had to go through, pull out anything medical related, and create a new file for every employee. They were kept in a separate file cabinet or separate file cabinets. And only certain people had access to them. I mean, I was the HR director, I was their boss, and they wouldn't let me look at them based on what ADA said. And that was okay, we had to comply with the law. But everything medical was stored separate and held very close to the vest. No one in general could look. Okay, now, employees, however, you could get medical information if it were obtained through a non-medical inquiry. All right, so I'll give you the example that I use, and I see the question now come up. I'll address it here in a minute, but let's say that your agency is housed in a multi-story building, and as you would typically find, one of the employees has been appointed as the fire marshal. Okay, and it's their role that in the event of an emergency, or for that matter, a drill, they make sure everything works the way it's supposed to. So the fire marshal sends out a survey to all the employees in the building. In the event we have to evacuate the building, do you have any special needs? Okay, so one of the employees indicates that a couple years ago I had a knee replacement, and ever since then I have difficulty walking downstairs. Okay, so since I'm working on the 3rd floor, I can't make it down the steps. So I'm going to need, some special help. Okay, so the fire marshal is now in possession of the fact that this employee has a health condition that will require a special accommodation in the event of an emergency. That information was obtained through a non-medical inquiry. So let's say that the fire alarm goes off in the building, and now the policy is that because I had a knee replacement, they're going to stage me in the stairwell on the 3rd floor. Fire department shows up, they're evacuating the building, and now the fire marshal goes over to the fire chief and says, we have an employee who's with an assistant fire marshal on the 3rd floor of the fire tower stairwell, and they're going to need help getting out. Okay, so they've divulged that information on a need-to-know basis that was originally provided through a non-medical inquiry. Thus, the Americans with Disabilities Act allows for that. Okay, questions have popped up. Barb, our township has FMLA voted on by the commissioners, and it goes in the minutes when the commissioners vote FMLA. Are we breaking the law? I don't think so, okay, because you're not divulging any serious health conditions of any particular employees. Okay, they do not disclose the reason for, oh, I see what you're doing. You're approving FMLA, you're approving leave. All right, Barb, I would suggest taking this conversation offline, but probably having a discussion with your solicitor. At face value, what you're presenting, my gut feeling is there's no violation taking place here because you're dealing with generalities. The basic question is, are you releasing any information that could disclose a serious health condition? If you're not doing that, then you're fine, okay? Now, Dorothy, aren't building plans exempt under copyright law of 1996? No. The engineer's stamp in itself does not represent copyright. And interestingly enough, you're a couple slides ahead of me. The engineer's stamp simply indicates that the engineer is qualified to prepare the drawings that are related to the building that is in question. Okay, they are not a copyright stamp. Okay, and I'm going to get into this. That's a great question, but you know, you're a couple slides ahead of me. You probably had your second cup of coffee, and you know, I'm just joking around. But I'm going to answer your question in greater detail here in a minute. Okay, Christine, he approved FMLA on agenda, but not the reason. Yeah, I think you're back here with Barb, and the question comes down is, are you doing something that could potentially divulge the fact that a specific employee has a serious health condition? If not, you're okay. Okay, but if you are, you want to revisit whatever your practices and policies are there and maybe come up with a workaround. All right. Again, good questions, and I hope I'm getting you steered in the right direction. Can you state in a record that a person took FMLA? It's going to depend on the circumstances. I mean, you know, FMLA covers maternity leave. Okay, well that, you can divulge that, maternity leave. Okay, but the question comes down, serious health condition. That's where you would have concerns over the use of FMLA leave and releasing that to the public. Okay, so you want to be careful about that, because if you're putting it in the minutes are clearly a public record. I hope you see my point here and what's important. Is it a serious health condition that you're releasing or that you can figure out through what you are memorializing in your minutes when your board is approving that? It's just something you need to be careful about. Okay, I'm going to move on. And whoa, okay, hold on here. Something's happening. I'm going to try to get back on track here, but I think we skipped a couple slides. Let me come down to Yeah, we skipped a lot of slides. What happened? I'm not done yet, folks. Hold on. I need to get us back on track. I think my PowerPoint crashed. Okay, yeah, we're back on track. I'm not sure what happened. And now, still acting a little wonky. Okay, let me see if any questions came up. Looks like no, we're good, and I'm back on track. Okay, next all we want to talk about, that was close, is FERPA, the Family Educational Rights and Privacy Act. Okay, this applies to school districts, and it is probably the most commonly used legal basis for withholding records. And it applies to any public or private school, primary, secondary, post-secondary, meaning colleges or trade schools and the like. And FERPA protects individual educational records. Examples being report cards, transcripts, records of discipline, and the like. Okay, now you're thinking, okay, what about when it used to be the newspapers would quarterly put lists of who's on honor roll this semester? Or what about the sports pages? These are students, okay? And isn't their sports activity also an individual educational record? Well, it is, but FERPA allows the publishing of that under what they call directory information. So, some of it's good, some of it's not. But, if in general it falls under directory, then they can release it. But most records related to individual educational activity would be considered confidential. Okay. Now, what about aggregated data? And you'll see this where school districts have all kinds of reports and surveys that they have to fill out, and they provide them to the Pennsylvania Department of Education, to the Federal Department of Education, all the uniform testing and so forth that they have to do. Well, that information, if it's aggregated, for the most part, it is considered public. That this year our fifth graders scored higher on reading comprehension than they did 2 years ago. Okay, so we're celebrating that. We're releasing that to the public. Okay, that kind of stuff is. However, we have had 1 or 2 cases here where the school district balked at releasing aggregated data because it could be sliced and diced in such a way that you could get it down to the individual record level. And it was based, if I remember the case correctly, it was based on ethnic data. They had a couple students who fell into very narrow ethnic categories. So when you reported the aggregated data and broke it out by ethnicity, you could see that, okay, this particular student got this particular score on this particular standardized test. And our office ruled that the school district was correct in withholding the aggregated data. It was an unusual set of circumstances, but we have advised districts since then, be careful. Take a look at the data that's being requested and whether or not you could potentially parse it down to the individual level. And we've advised them, when in doubt, withhold the record and we'll sort it out here if it gets appealed. Quick sip of coffee. Yeah. Next one, we will occasionally get calls from frustrated parents who have filed right to know requests for records related to their child. And the school district has invoked FERPA. Okay, now technically the school district is correct. But what the school district failed to do then is turn around and tell the parent that FERPA in and of itself includes a mechanism to get your child's educational records. Okay, shame on the school districts for not doing that. I think, you need to look beyond right to know and realize that you've got a parent with a situation where they need a record FERPA allows them a mechanism for doing so. Maybe filing a right to know request is not the right way to get that record, but I think you've got an obligation to that parent to let them know that through FERPA they can get the record. So just bear that in mind. And then if you're dealing with law enforcement, like campus police or whatever, okay, those records typically are not protected under FERPA. All right, those police records, fall under the jurisdiction of that appropriate police force. In recent years, there has been an evolving body of case law dealing with videos that are captured by school districts, and school districts have attempted to invoke FERPA. Unfortunately, the best answer I can give you is it depends. Okay, there are court decisions that have said FERPA does apply, like if it occurs within the school building, during school hours and the like, and the videos are not released. There are decisions where the courts have said FERPA does not apply, like on a school bus after hours for a sporting event. And it didn't particularly involve students. So FERPA doesn't apply. Then we have some court cases where the courts have said, you release the video, but you shade out the students' faces, okay? And I think that's where we're at now, most recent case. And even that is several months old. So this is kind of like an evolving area of right to know law. And we're still sorting it out, okay? But, it takes a couple years and the courts will get there. And then clearly student health records that are in possession of a school district, they would be withheld from public release as well. All right, so advance, I hope that it works. Yeah, okay. The Pennsylvania Public School Code is kind of an extension of FERPA. It does have stronger language when it comes to health records. You're thinking, okay, why would a school district have health records? Well, you've got a school nurse or a nurse's assistant, and you've got a student who needs an injection, let's say, every day at lunchtime. Or, they keep prescriptions on hand. The student is not allowed to have the prescription, so they go to the school nurse's office and they would supervise giving the student a pill, at some point during the day because of a medical condition that they have. Okay, that's fairly common. And any records related to that would be protected under the public school code, the Pennsylvania Public School Code. Clearly, in addition to all the other laws, you could rely on the public school code not to give out any information related to health records of students. Okay, next one. This one comes up not as often as it used to, but it still comes up. The Pennsylvania Motor Vehicle Code protecting any driver's records of public employees. Okay, and now the Motor Vehicle Code protects everybody, but here we're talking about right to know law, government agencies. So a government agency could invoke Section 6114 of the Motor Vehicle Code to withhold the release of any individual driver's records. Okay, now under the Motor Vehicle Code, a driver's license is considered an individual's authorization by the Department of Transportation to operate a vehicle. Okay, and that would include commercial driver's licenses. And periodically we'll get word of a right to know request submitted to an agency saying, I would like to see this employee's driver's record because I think, I think he got a suspension and I saw him driving, a borough car, and I don't think he's allowed to do that. Or I saw him operating a piece of equipment that I don't think he's qualified to do. I want to see a CDL. Okay, well, the agency can invoke Section 6114 of the Motor Vehicle Code as the basis for denying that request. Okay, but let's say you've got an employee with a lead foot and they've racked up a couple speeding tickets to the point where their license is going to be suspended or whatever, and maybe it made it to court, maybe there's a DUI involved or something like that. Again, because those would be court records, they're discoverable under the court's Rule 509 process. Okay, but the basic licenses and stuff aren't. All right, moving on. Okay, here we are for Dorothy's questions about the copyright law, and I've kind of shown my hand here a little bit, but let me get into this because this is kind of fascinating. The federal copyright law applies to anyone claiming intellectual property in the form of authorship. What does that mean? Well, it's like, okay, I prepared these records, and within them is my original thought. It details a really great idea or really great approach to something. So because of that, I don't want anyone else claiming credit for it. I am invoking copyright per the Federal Copyright Act of 1976. Okay, so this law protects those records when the author is claiming original thought. For our purposes with government agencies, you typically see this with an engineer's drawings or an architect's plans and drawings. Now, when you see a drawing, you'll usually find a stamp on it, okay? Take a close look at that stamp because it does not necessarily represent copyright. Most plans will have a stamp on them, put on by the engineer or the architect who prepared the plans. They are licensure stamps. And what that means is that I'm the architect who came up with this drawing. I'm affixing my stamp to show that I am certified, registered, qualified to prepare said drawing. And that's all it means. Now, if there is a second stamp, there's a good chance, but you have to look at it, that it might be a copyright stamp. And this is where the individual is saying, on this drawing, it represents original thought. Okay, I've brainstormed this, I've come up with a new idea that I don't want anyone else claiming credit for or misusing. So I am attaching copyright in addition to showing that I'm a registered architect or engineer that prepared these plans. Now, engineers, I think, would need to be very careful about claiming copyright because typically anything an engineer prepares has to follow basic standards of practice. Something like stormwater runoff drains and so forth. There's a right way to do it, an acceptable practice by all engineers into how you properly design a storm runoff system. All right, and if you deviate from that standard of practice, you could potentially open yourself up to liability. So claiming original thought for a standard practice wouldn't happen. And usually, I think it's very rare that you would see copyright for something prepared by an engineer. An architect may be something different, okay? I was just talking to somebody yesterday. I was at the state convention for the Boroughs Association and talking to a borough manager where they were designing, what do you call that? A band shell sort of thing. And the architect came up with something unique, okay? And they're claiming copyright. Just a general conversation. There, I think, copyright for the building plan may be appropriate, without knowing all the details. Okay. So where it gets a little confusing here is what can you release if it's copyrighted? Well, based on a court decision, Ali versus the Philadelphia Housing Finance Authority, what the Pennsylvania Commonwealth Court said is that if you want a copy and it's copyrighted, you can't have it. However, if you want to look at the document, if you want to inspect it, under the right to know law. You can, okay? Now, walled questions come up. Can an individual take photos while inspecting? No, they cannot, okay? Or at least they shouldn't be able to. But you need to understand the purpose of the copyright law, okay? In the dispute, any dispute that would arise has to be between the person claiming copyright and the individual allegedly misusing that copyright. Now, taking a picture of a copyrighted record in and of itself, in my mind, and this isn't legal advice, this is just my perception, is not in and of itself misuse. But if I were to take that picture and claim that it's my original thought and not that of the author, well then, that's a different perspective. It depends on what the person does with the photograph. And does that represent misuse? That would lead to the dispute. And again, the agency is in the middle. The agency is not a party to the dispute. Okay, it's between the person claiming copyright and the person allegedly misusing the copyright. That's where the dispute falls under this law. So it gets, pretty convoluted. And this is a complicated law. And I'll be honest with you, I remember watching the arguments for this case, and I thought the court was going to go in a completely opposite direction. And then when the ruling came out a couple months later, it's like, wow, I got that one wrong. Okay, but this is where we're at today. And this decision was several years ago. Okay, and it stood the test of time. So that's where we're at when it comes to invoking copyright. And Dorothy, I hope that addresses your concerns there. Okay, we're getting near the end here. Child Protective Services Law. Okay, this covers anyone who in the course of their employment comes into contact with children. And it would also involve volunteers. Okay, now you're thinking, all right, we're a government agency. Why would this be important? Well, what if you have like a summer parks program, okay, where kids, come during the day and, there's activities there for them to do. I don't know whether you still do that or not. It happened when I was a kid, way back when. But the Child Protective Services Law protects, excuse me, any reports, summaries, medical evaluations, file notes concerning the investigation of child abuse, okay? So what if you have a parks program and you have kids showing up and the program is staffed by volunteers, but a kid shows up with some injuries that kind of raise some eyebrows. And it's like, well, under this law, the volunteer, if they suspect child abuse, they are legally bound to report their suspicions. That starts an investigation, starts a paper trail, and all of those records then are protected, are considered confidential based on the provisions of this law. And the person initiating the report, anyone conducting the investigation, okay, any confidential informants and the like, or I should say that anyone initiating the report is treated like a confidential informant. That information is not given out. Okay, now, where it becomes an issue for the agency is where you've got domestic issues. There's a divorce taking place, it's getting ugly, and there's a child abuse investigation in the middle of it. And one spouse is claiming that the other spouse abuses the kids, and the other spouse is denying it, and they want to see all the paperwork related to the investigation. And you get caught in the middle of these phone calls and emails and so forth, and your heart goes out to it because you know that given the heat, the elevated emotions, that things are being said that may not be true, may not be accurate. However, you've got to withhold this information. Don't take it upon yourself to hint at what the investigation may be disclosing. All right, don't put yourself in an untenable position in the long run by releasing information that this law clearly says is confidential. Okay, and then finally, if you do have those clearances for your employees, for your volunteers, any information related to documentation that was used to obtain those clearances is also considered confidential. The fact that a person has a clearance can be released to the public. The fact that, you know, the forms that you have to fill out and everything, that's considered confidential. Another one, this one hasn't come up in a while, but if you're involved with like an area agency on the aging and you've got employees, they are under a legal obligation to report any elder abuse for someone over 60 who can't provide for themselves. Okay, just a real quick one there. Disease Prevention and Control Act of 1955. This hasn't come up in a long time, but it's related to COVID. And back during COVID and for a couple years after that, there were disputes over right-to-know requests submitted for aggregated reports. The Department of Health and a couple county health departments invoked this law as the basis for not releasing aggregated data. Our office ruled against that. We said that this law doesn't allow for the release. It got appealed up to, I think, the Commonwealth Court. I don't know whether it made it to Supreme Court or not, but essentially those courts affirmed our ruling and said, look, you know, Act 55 doesn't apply for aggregated data. Last I knew, the legislature was also taking a look at perhaps amending this law to make it more clear that it does allow for the release of aggregated data. I don't know where that's at. I think it's still bogged down in committee or whatever. I don't think they ever actually passed a revision to this act. But, you know, if it ever comes up again, that's where case law stands on this. Okay. And just some miscellaneous stuff as we're wrapping things up. We see this a lot. People submit right-to-know requests for W-2s for public employees. They want to see salary information. Okay, well, the IRS says it doesn't get, you know, W-2s are not released. Okay, that's private information. Then in Pennsylvania, we also have the Taxpayer Bill of Rights, which makes it a misdemeanor for any agency to release confidential tax information. There's also another law called the Local Tax Enabling Act, also referred to as LT. If any local agency or state agency for that matter is conducting an investigation into tax payments, that doesn't get released. And then home addresses, used to be home addresses were considered fair game. The courts, there's a very well-established body of case law now that says home addresses and dates of birth are covered by the Pennsylvania constitutional right to privacy. Okay, so they would not be released. Dates of birth, the month and the year can be released, but not the actual day. That's where case law is at now. I realize that still raises concerns about identity theft, but, you know, like I said, that's where the courts are right now under the Pennsylvania constitutional right to privacy. Okay, that's pretty much where we're at, but Christine has raised a very good question. Election information, since this year will be big for that. Okay, what I can tell you, Christine, is that I can't provide you with definitive answers because this is an evolving area of right-to-know case law. There are cases that have just been released by the courts within, I'm going to say, the last 3 months that cover what an agency can release and what they can't. And we do not yet have a clear picture. Okay, our office has released decisions. Those decisions have been appealed to higher courts. Some instances, the courts have ruled. Some instances, it's going to be a couple years before we see, you know, where this all lands. I do think that number one, there's information that you can't get through right to know that you can get by going to the Elections Bureau. And under the Pennsylvania Elections Act, there's information that you can obtain under the Elections Act. There is some information that you can get aggregate data, but not like individual. It comes down to computerized voting. And let me just, I don't want to misspeak here, but you can't get like the form I fill out that gets submitted into the voting machine. But then people were submitting requests for the electronic readout of what was submitted into the voting machine for an election, okay? And that became very problematic because you could kind of see how individuals voted. But I think our office ruled that that information, given the reading in the election law, could be released. Okay, so I think that's where the dispute currently is. Can those reports be released based on the language in the elections law? And I think that is still working its way through the courts. And I'm saying that with my fingers crossed that I hope that's accurate, but I would need to do research on that. But Christine, to answer your question, I'm not going to cover that anytime in the near future because it could change the next day. You know, I think that's where the dispute is now. The courts have yet to rule on it, and that's what we're waiting on. Okay, but I'm with you in saying that, gosh, I wish we had a clearer answer to this, but the answer is not yet. Okay, borough. If you said this, I apologize, but what about names and rates of pay for borough employees? I did not say that, but I will say now that that's clearly public information, okay? The public has a right to know what public employees are being paid, okay? And you get that through payroll information or, you know, for instance, state employees. You want to know how much a state employee is paid? They have a website, PennWatch, that you can go to and query on the name, and you can see how much that employee was paid last year, okay? If you're not doing it already, you should be doing it. Okay, another one. We get requests almost monthly asking for a copy of the database where the district maintains tax collection payments. Okay, tax is funny because this came up yesterday at the conference I was at. Under the Pennsylvania tax code, tax collectors are not subject to the right to know law. Okay, they do not have to respond to right to know requests. If, however, the tax collector has provided a report to the agency, to the borough, township, whatever, and they are in possession of the tax information, then they have to respond to the right to know request. It all depends who's in possession of the tax information. Okay, and then, you know, you would take a look at those other laws to see whether or not they apply or not. But it's who's in possession of the tax information. That's the first question that you have to answer. Okay, we have requests for salary, phone number, address, name often as a school district. Do we need to release the phone number? No, if it's a personal phone number, that's protected under the right to privacy. Same way with the home address. And if you need further information on this, Betty, you can talk to your solicitor. But the seminal court case is Campbell versus the Pennsylvania School Boards Association. Or you may find the reference Campbell versus the Office of Open Records. But that's where the Supreme Court developed the language on the constitutional right to privacy that protects, and that was the original case, it protected public school teacher home addresses and phone numbers. And then since then, it's expanded to include just about everybody. But no, you would not release that information based on the constitutional right to privacy. Okay, let me see if we've got any more questions that have popped up. And no, we haven't. And I think We're at the final slide. Yes, we are. Okay. If you've got any more questions, now's the chance to get them in. But I appreciate the questions that you've had so far. Yeah, the election one, I feel bad about not giving you a more definitive answer, but that's just where we're at. We're waiting for the courts to provide clarification on that. And it's going to, the way things are, it's going to take years. But in the meantime, take a look at our website, okay? Because a lot of your questions, if you get in there and dig, you can find the answers, mostly in our final determinations database, where you can search through 30,000 plus decisions on how we have ruled on these cases. You can also find case law. Many of the case law references that I've used here today, you can find the actual decisions in our case law index. But in addition to that, we've got guides for citizens on the right to know law, agency guides. If you are an agency open records officer or right to know officer, you can download our handbook, our guidebook, 78 pages for free, and there's all kinds of helpful information in there. And then you can just become aware of training opportunities that we have by looking at the website. And these webinars, get scheduled ahead of time, and they're on the website as to when they'll show up. But again, I want to thank you for your participation today. Oh, here's the question. Does an agency have the right to make a policy to only supply right to know request funds? No. Under section 70, it's either 701 or 703, you are obligated to provide the record in the medium in which it exists. Okay, medium means hard copy versus electronic. So if you have the record in electronic medium and the person requests it electronically, that's how you have to provide it. And Dawn, I covered that in 2 other webinars. The first one is Basics of the Right to Know Law. The second one is payment issues in the Right to Know Law. We go into that in detail. But, good question. And hopefully I've given you, enough to move forward with. But take a look at those sections of the Right to Know Law. Anything else, folks, before we wrap it up today? I'll be back in 2 weeks with another topic. It'll either be, gosh, I got to see what's on the schedule. It's either going to be Basics of the Right to Know Law or Basics of the Sunshine Act. Okay, we're going to log off here today. And again, thank you for your participation. Get out there and enjoy the nice warm weather.